Everybody say, say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. So Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. See, I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. You're my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Are you ready, everybody? All right, listen. Boy, me ground cover. 1, 2, set.
Welcome to BWF Solicitors, a trusted and experienced family law firm specializing in immigration and naturalization, as well as dispute resolution. Meet Bernard Owusu, our esteemed senior partner with over 30 years of experience and known for his expertise and dedication to serving our clients and the community. BWF Solicitors stand for integrity, respect, excellence, teamwork, diversity and inclusion, and service to the community. We provide tailored assistance across all areas of UK and Ghana law. At BWF Solicitors, every day is filled with dedication, creativity, and a commitment to finding the best solutions for our clients. Led by experienced senior partner Bernard Owusu, the team at BWF Solicitors is ready to assist you with your immigration, naturalization, dispute resolution, family law, new wills and probate, Ghana law and practice needs. We are dedicated to providing solutions to our clients' problems. You can find us at the 4th floor, Anna House, 214 to 218 High Road, Seven Sisters, London, N15 4NP. Main office line 0208 493 7340 or our emergency line 07712 761 884.
Good morning, good afternoon, good evening, depending on your location. Welcome to another edition of BWF Solicitors Legal Hour with Manye Ten. Mejidi se obi bia ohwe mi anope ankrankran bia odu fide ato ha ho ye na adom ne da so kra wo. Ene nso enigesem ahodimo ene enhu akikai se yenya emre na yɛde saa dwumadie ba wa akwami bom. Aha yɛ BWF Solicitors for omo education omo de ba every Friday na yɛnso yɛnya adusua efiri mo. Enti ene bi na yɛde ebrɛ mo no ene adom ne nti no yɛasa na yɛ dedication de ba media ne manyeti wohyia baabi a wofrɛ manyeti a megye so na ɛna yɛabɛ yɛ mmerɛkɔ kakra nti bɛdi kan na yɛaka ɛba no BWF Solicitors a nneɛma bebree ɛna ɔmo yɛ ebi yɛ yɛfrɛ no sɛ immigration nsɛm ebi yɛ family law nsɛm ebi yɛ litigations ɛna mpo yɛ kurom Ghana nsɛm nyinaa ɔmo di ho dwuma na yɛka ade a ɔmo abene mu yie papaapa no ɛyɛ immigration ne family law ne deɛ ɛnɛ yɛabɔ ɔmo aba so saa enti ɛnɛ yɛba abɛhwɛ nansa na yɛbɛba no medi kan ma me resource person ɛna mewɔ ɔmfa nkyɛ akɛseɛ ɛma mo na afei deɛ edwuma a yɛwɔ ɛnɛ no na mede aba abɛto dwa ama enti medi kan afrɛ no lawyer Asmah ɛyɛ me dɛ ɛyɛ me nigye sɛ ɛnɛ me no ɛyɛ program yi nti mema wakɔ aba ɛbɛ fidie yi so na mema wakwanya nso na wode nkyia kɛseɛ ama etiefoɔ ne ahwɛfoɔ.
Yo na yɛkyia obi biara a ɔhwɛ yɛn ɛnɛ anɔpɛ yi anaasɛ ɔretie yɛn ɛnɛ anɔpɛ yi ebi a wɔ biara yɛde nkyia kɛse ɛbrɛ wo fi BWF Solicitors asɔeɛ ɛne afidie yi so. Ɛna nso yɛhyia sɛ yɛbɛdi nkɔmmɔ ɛnɛ nkɔmmɔ no ɛfa employment rights ɛho nti woyɛ obi a woyɛ adwuma be it employee worker or wherever you are a woyɛ adwuma wohyɛ obi ase woyɛ adwuma ma no ɛnɛ woyi ɛyɛ wo dea ɛna woyɛ employer nso a woyi nso ɛyɛ wo dea ɛfiri sɛ asodie no nso ɛda wo nso wo so. Nti we are going to learn about flexible working arrangement. And then aban say nhyehyɛ a ebe take place from 6th of April 2024 no nyinaa yɛhwɛ kwan.
Yo, last man, me da see ye with the wa introduce me question ne kra and me topic na me tie for ne nyina ye. Na ne woman say answer na ebekɔ ene the main topic e de bremo no. Yenim say enigesem kakra emma enkrofo bi attitude for care workers for modi care route by school migrant route by krom ha. Na yenkɔte a just last few days and a few weeks ago no. Omukɔ kan parliament say de ye hu say dependents eka skill workers here by eni say omukunum and omoyerenom ene omoma no eya adoso dodo chen omukra na omo ya form edwuma no ntine e wom ni say sisi no fiti next month ekono ye ma obi biara emfa ne dependent enka ho bio na emom omo de mre eba just last week and this week and no more specific any emra no eba yourself fiti on the 11th eko we application be ama independent dependent ye fa emma no na mom eni jesem kakra e wo mu ni say senia na ye di kan ete ye no sesiem say o masese o madwen mu kakra yenko ti a ye say wo mu afi na wo bo afi kra na wo dwene ho ye ma wo mfa nka na mom omo ni sisa kakra bi nti mebisa lawyer Asmah update abesi akọ this week on boso kakra nkyere ansa na ye the main topic no e ba betudwa e de amamo misrewo lawyers Asmah pacho update e ba system no boye nkomo kakra mente wonka lawyers Asmah pacho mente wonka na mente lawyer Asmah nka yo osiesi na ne fidie no sisi abete wonka nti se wo ka me ma wa kwenya na wa kire update kakra aba system ne mo.
Right. So na yenim say aban say spring of 2024 changes ebeba efa skilled worker migrant program no especially dependents ebe joining the main applicant omo UK and as a full no omo ba no. Now you say spring will be between March and April, but aban MIA who say it's going to be 11th of March 2024, which is about 2.5 weeks, thereabout, or say 3 weeks. But first, aban na say enka obi a owo mu die owom and to between in the family aba as dependent anytime. And aban science san adwin say afide obia, it doesn't matter. But the good news is say aban afide we sisu dia say wo mu dadade a ende ohoson we your application no by 10th of March 2024. So from 11th of March 2024, that's when the law takes effect. Until one obey application by 10th of March. Say application is done. Say visa number. Of course, your refusal there is a different point. But say them unless I watch channel, you are exempted because I buy a use the word unless. And because of the word unless, it says unless, then all those who are already in, they are covered. They are covered. Into one afi number from 11th of March, only you can come to the UK to work. You cannot bring your dependents. So what is the lesson for everybody? So application year before 10th of March. So person would dependent eba, of course, now it's flexible if you're already here. So whenever you are ready, you can put in the application. But the earlier the better though. And so the two and so by 10th of March, only ebusuafoni na betumi aye at the same time. And now say after that, no betumi aye one so one day no ama. So take note, 11th of March is the beginning of the new change, which restricts skilled worker migrant on the care program, shortage occupation route, or code 6145 and 6146. 6145 general carers, assistant support, all those ones. And at 6146 no senior carers. Until South no, we hear our application from 11th of March. We say unkwana na ubetumi aba, untumi mfa dependent enka ho. Sarah also and from that time no, so we care provider na only CQC from Care Quality Commission and register ya untumi enye ejuma because sa ejuma no abeye regulated activity, and so you have to register with the regulator before you can pursue sa ejuma no.
Yo, lawyer Asmah, you better was say, ye need some because ye na ye tin some no na atu ebimu ayem shishie because bibia ne mono ye disca na ye say even pododo na edi kan buy na ebimu kra hu omo ho ano no ma akofo mo yere no ne omukunu ma ba enti e ba ne sa no na che say omo agija na che say omo ntumi anto anamo within these 2 weeks here na che say no na so sa good news abi at least o masum bedru omo kakra onye adwuma kakra onye sika ye de twa plane ticket ye de to visa na we visa fee no na we twa plane ticket no omo yere no na na omo adofo no na omo mba no aba be come ho nte ye ni jesem ye beda home office fo ase ana parliament ase se da bibiara omo dwene ye ho na lent nso se we bi call so ye kan say petition bi e call round bi de mehu bi mom na nkrofo na ekeka petition bi call round sa na em say akoto mpanimfo n'anim ene say omaye hu bibi say ye nokre say nye nokre nsisa na aba ntimi gidi say eye nokre yo lawyer Asmah ye da siye ene ne woman ni say ye beka emra eba ewo flexibility in terms of working hours na ne minimum ni say emretia weni ana few years ni na corona ebe dwirigu mu coronavirus by esisa nioma bebre na me gidi me 100% convinced say sa regulation ya ye change kra ebe nam corona ho hihye bi a ebe se nko kra ebe influence bi na ama ye de san hihye eba na corona time no ye ni ama lockdown ma mompie monhyɛ fie na mondidi na monda na monyɛ adwuma wɔ fie ana afei yɛbɛbiebie mu nso no na awofoɔ no bi abɛyɛ used to ɔmo kwala ahwɛm ana ɔmo fie hwɛm with adwuma ɔmo abɛblend ama abɛyɛ yɛ ɔmo dɛ ebi mo nso nsɛm pii nanso no government na ahwɛ there could be other factors nti sɛ wonim wo a wohwɛ me wonim baabi na me mbɔɔ so a in America there are so many factors ama ene saa nhyehyɛ yi eba enti ene no megye di sɛ wotie me no wontie me kɛkɛ na mmom saa deɛ wei etumi affect obi biara edwuma bia wom bia no etumi affect wo enti no mesrɛ wo mmom eni die mu wonya ba so a share the program like the page na subscribe to our YouTube channel no sɛ ne ɛbɛyɛ a abere bia yɛba so a na wehu sɛ yɛaba na doing so no nso na kyerɛ sɛ ɔsɛ notification button na ɛwɔ hɔ ɛyɛ aban adɔm na ɛwɔ hɔ na ɔsɛ wo click on to all notifications na wonya enti no monhyɛ dodoɔ no a maba so nyinaa mede nkyia kɛseɛ efi studio ha ɛde ma mo dodoɔ na adan mu no nkom nyame nka wo ho wedi kan aka sɛ yɛnhyɛ program no na nkɔ kyikyikyi saa na agyema na nie na mete wo nka akyɛ ɔno nso saa ɔsɛ monhyɛ program no na ɔbobɔ rokɔ wɔ hɔ no wafrɛfrɛ adɔfoɔ bebree dɔkasa dom Margaret Edumensa Nana Bob Tili Duma Tili Etisɛn megye di sɛ wo ho yɛ Wumpini Adams ɔsɛ best FM best firm in the world with many years of experience. Please contact or connect this firm for all your legal matters, which is 100% true. Wumpini nyame nhyira yɛda ase paa yie. Tili monkɔ so ana monhyɛ ɛma yɛ dodoɔ no a moba so na mesrɛ monhyɛ na ɛto ahene monhyɛ na nkɔ akyi. Tili say please kindly share, comment and like. Comment ne deɛ ɛnɛ ehia me paa ɛnɛ meduane a media yɛ mo comment a mode bɛba nti mesrɛ mo na mon comment saa nso na me nua series you know, I don't know if I pronounce it right. That may share with me why. I see series Fraser. I see please share. We do not take your support. We do not take your support for granted. We are most grateful. Mama Sherry, Anna, brother Sherry. I don't even know if he's a male. But it's all good. I see share na him. So like no, and then you become flexible working. The new flexible working regulation which came I think omo di ho dwuma last year and it's eba into reality nyame adoma next 2 months a shall say and then what do I do if my employer says no to the new request but ye bedi kan ebisa lawyer Asmah and ye woman say as our flexible working hours yen di kan embisa o say kan no na deɛ na ɛwɔ hɔ na regulation bɛn na ɛwɔ our working hours ho ansa na ɔmo pɛ sɛ ɔmo de nsesan ɛba no nti o ma mmienu mmuaeɛ a na afei mebisa nsesan no nso a aba no nso na wakyerɛkyerɛ yɛ mu kakra na afei nkɔmɔ a questions a mewɔ no na mebisa ɛtoatoa so nti no sesia no this new flexible working regulation now we will see new flexible working hours for every employee Mr. na deɛ na ɛwɔ hɔ deɛ how was it deɛ na ɛwɔ hɔ ansa na afei yɛde nsesan bi ɛpɛ sɛ ɛba wobɛtumi akyekyere mu kakra
na that's the bebree viewers and listeners and then come on no senior your boss no it's about flexibility with work pattern in the workplace buying a codifier flexible working regulation 2023 but the effect will be from 6th of April 2024 na dan na ɛwɔ hɔ yɛhwɛ the Employment Rights Act 1996 yɛhwɛ section 80 G F ɛkɔ no a into section 80 so to speak in one one obeka kyerɛ say we employee a wo tumi say ubisa employer no emma of flexible working arrangements yɛbɛbobɔ some of these flexibilities but you should have worked with that employer for 26 weeks. So not just say if you have not worked for 26 weeks, you didn't have the right to request flexible work arrangement. But let me take you through what existed before. Nti yɛhwɛ nana ɛwɔ hɔ no a, ɔse first 26 weeks. So you should have been an employee for 26 weeks. Then you put the request in writing to the employer. The employer will have 3 months to respond, or longer if they negotiate the extension with you. The employer will have to come back to say yes or no. If no, they can cite business reasons. And it could be any business reason that the employer deems fit. And that will be the conclusion that they say no. With the change, what is going to happen is that from the 6th of April 2024, 26 weeks will change to 1 day from the very first day of your employment. So you don't have to wait for 26 weeks before. So that is that point to be made. So changing from 26 weeks working as an employee before you can request to the first day as employee you can request. But what is flexible work or working arrangement? It means you work either part-time, you work either mixed in terms of remote and physical location. You can also have mixed hours. You can start early, finish late. You can compress your hours, and so on and so forth. So for example, I'm supposed to do 8 hours a week. I can compress my hours. If I'm supposed to start at 9:30, I can say, based on my peculiar circumstance, arrange with the employer that I will start at 8 and move my closing time from 6 to, let's say, 4:30, provided I can still make the hours. Or I'm going to forfeit my break so that I can make that time as part of my working time, because break is a right. Or I want to make it flexi so that I work as many hours I can within a particular day. So instead of 5 days a week, I compress it to 4 days for the need I have. And the need is personal, familial, that's family. So the employer, yes, you have to tell the employer the reason. But the employer cannot say this reason is not tenable or reasonable. The employer will give you excuse as to why they cannot do before. But now, the restriction is high for the employer. They cannot use business reason to refuse you. We'll come to that. So, we have gone through the fact that it used to be 26 weeks before you can request. From day one, working for 26 weeks before you can request. It used to be that the employer you have to put the application in writing to the employer, or make the application in writing to the employer. Employer no SSO responding within 3 months before it's changed. We'll come to that. The employer can ask for extension to respond. That means they can even say, we'll get back to you in 5 months for good reason. That is, if they tell you that they cannot respond as soon as possible within the 3 months and you agree to that, they will come back to you. So you give extension of time. Then they can come back and use business reason to say no. But what is the new rule saying? The new rule, in order not for viewers and listeners think that lawyer no but now all can I'm going to read from the script itself. Buying a publishing. Into say from 6th of April 2024, employees, and mind you, employees or employee is defined under section 230 subsection 1 of Employment Rights Act and include workers. If you are a self-employed person, you are not an employee. This is not for you. How do you know you are self-employed? There are certain things that will show that you are self-employed. Case law tells us that certain things will show. For example, the case of Ready Mix Concrete Limited will tell you, and many other cases before and after that, will tell you that if you're an employee or you are a worker and you pay your own tax, you pay your own national insurance, you arrange your own pension, you have to make sure that the work you are doing, you have arrangement with the employer to the effect that you are not paid a salary, but you are paid a fee, a commission, or anything. All these things will suggest that you are self-employed. Rules and regulations in the workplace are not restricted to you because you are self-employed, insofar as it's necessary. So the case law is there for those who are self-employed and those who are employees. If we look at the case of Uber, the case of Uber came some that was late 2020, 2019, thereabout. We know that it was concluded that Uber drivers, though they are drivers working for themselves, because of the arrangement the Uber company has with them, some of them are employees and some will be self-employed. So that is the distinction between employees and self-employment or employed persons. Because today's conversation is not about self-employment and employment for service or for contract, I'm not going to go deeper into that. But suffice to say that this rule, a flexible working regulation 2023, is for employees. It is not for self-employed persons or workers. So, it's starting from the 6th of April 2024, and you have the flexibility to request. That means you have a duty to request. If you don't request, you won't get it. And you have to request by making an application in writing. Making an application in writing. So if you don't put in the application, and if the application is not in writing, it will not be considered as a request. So if you meet your employer or the manager in the corridor and you tell the manager or the employer that XYZ, so I want to go flexible or flexi, that is not how it must be done. It can be forgotten and it can be denied. So it has to be in writing, given to the employer. And it can start from day one of your employment. What is day one? Day one is when within your contract, you are supposed to start work. So if your contractual arrangement or your employment contract says that you are reporting to start work from day one, let's say 23rd of February 2024, that is your day one. Right from that day, you can put in the request, provided you have the request in mind. The next thing is that, as we said, it can be done twice within 12 months. Twice within 12 months. So you can put in the first one day one, and once your circumstances have changed, you can put in another one. Insofar as it is the two applications or requests are made within that 12 months. That means it can be made within 12 months. And here, we can extend the law or stretch the law. Because the law doesn't say it has to be made twice within your employment tenure. It says twice within 12 months. That means every 12 months, you have the right to ask for to make two flexi requests. That is the point to note. Employers will not be permitted, and the key word here is not. Employers would not be permitted to reject flexible working requests without consulting with the relevant employee. That means before you reject, you have to have a consultation with the employee to discuss why you want to reject that application. And if the reasons are not tenable or reasonable, it will not wash under that circumstance. Then the next thing to note is that the outcome of the request should be delivered in writing. So the employee has to make the request in writing. The employer has to respond in writing. You cannot just verbally tell the employee that yes or no. It has to be in writing. So both the request and the response must be in writing. Before the change or before 6th of April 2024, when the new law comes into effect, the employer had 3 months or now has 3 months to respond and can even extend it. But from 6th of April 2024, the employer has 2 months within which to provide response. So it says that the outcome should be delivered in writing within 2 months of the date the request is made. So if the request is made on the 23rd of February 2024, let's make it simple. So the next month will be 23rd of March, and the next will be 23rd of April, 2 months, if we are making it simple. But depending on whether the month ends 31 days or 30 days, you can tell how many days, and you can work it out. It says within 2 months, the employer must respond. If the employer doesn't respond, then there is consequence. And here it
Lawyer
says,
Charles, Lawyer
yes,
Charles, 1 second. I think we are rushing a bit here. Let's take our time a little bit. The different you are now giving us the difference between requesting and getting response. Is that it? What you are okay?
so,
So at the first one, we've gotten to know that if you want flexibility in your working hours, then you have to put in your friend is saying your request in, like you have to apply to the employer, say you want to change your working hours, say ni. Okay, now employer no 3 months before 3 months to respond to you. Say waji atum say onje ntumo or 3 months or beye. And as so no automate catch or say manimre kakra account, so it could be 4 months, it could be 5 months just to get back to you and son or beboa. But you say old one sanity, but see a new one now omode abano. Say who put in such a request abane try and say or say employer need to me responding to you what within 2 months. But you sanity.
that is
Aha,
here.
say a tear na enkoye mu ye because I say na ye rashi kakra nti no afi ubetumi ato ase free.
Very good. So let's put them side by side,
Okay.
before and
Uh-huh.
after.
After. Mm-hmm.
So before will be up to 5th of April 2024.
Mm-hmm.
After will be from 6th of April 2024. For the new
24.
law will come into effect from the 6th of April.
Okay.
Before or
Mm-hmm.
now up until the 5th of April 2024,
Uh-huh.
you must be an employee who has worked for the employer for 26 weeks
26 weeks. Okay.
before you can request.
Mm.
So if you haven't served, you cannot go flexi
Okay.
before. From
Okay.
6th of April, it
Uh-huh.
doesn't matter. As long as you have become an employee, from day
Uh-huh.
one, you can request.
Request. And even abra ube wa ya wa your application na ya ma offer now you can put up your requested flexibility. Emma employer now on accept it. But just anete.
And when I say from day one of your employment, that means you report to work on day one.
Uh-huh.
Having
Okay.
reported, because one bad can be said you change your mind.
Okay.
Having reported to work on day one, your
Okay.
right to flexi work will start,
Mm,
and you can
mm.
make that application from that day.
Okay. All right. You.
Before, the employer must respond within, so it must be in writing, and it
Mm-hmm.
still must be in writing. Before, the employer had 3 months.
Mm-hmm.
From 6th of April, employer will have 2 months to respond.
Okay. Okay.
And the response should also be in writing.
Mm-hmm.
Before, the employer
Mm-hmm.
could say that I need extension of time to give
Okay.
you response.
Okay.
What does it say? It
Mm-hmm.
says that the outcome should be delivered in writing within 2 months of the date of the request,
Mm-hmm.
unless an extension is agreed between the parties. So still there's extension provision.
Mm-hmm.
There's still extension provision from the 6th of April. So the employer can still request extension to respond, extension of time to respond. But the time to respond, that extension must be agreed between
Mm-hmm.
who the employee, In this agreement, na unilateral. So employer no say no. To yen to me respond anti train kakra. No. You must call me, we sit down, we agree that, okay, under the circumstance, we are able to respond maybe give us 6 more weeks or 1 more month. Then I will agree to that. Once I agree, then it binds on both. Then I have to wait. Unless it is agreed between the parties. If it is not agreed between the parties, then the employer cannot take a unilateral stance to respond after 2 months. So those are the parameters with the new law. And because of that, ACAS will revise its policies. And say ACAS, a government body, ensures that both employers and employees are happy
Mm-hmm.
and rights are protected and responsibilities are also respected
Mm.
mutually, not one-sided. What
Mm.
it means is that ACAS from 6th of April, they've started taking the steps.
Mm.
So if you go on ACAS website now, you see snippets of what is going to happen in terms of flexi work because they
Mm.
have to change the policy to reflect what will happen.
Okay.
Now, let me also take you to what the Minister for Employment has said
Good. Okay.
about this new arrangement and the
Mm.
benefit to both employer and the
Mm-hmm.
employee, and
Mm-hmm.
even the country or the nation at large.
Okay.
Now, we are looking at the business case for this policy. Remember, every policy has a social need to it. So the human face of the policy. The human face is this.
Mm-hmm.
If you're able to give people flexibility, they become loyal, they die for you, and they do everything to ensure that your business succeeds. If you are strict and stringent, it kills desire, it kills motivation.
Mm.
So what the Minister of Employment is saying is that this is good because we want to keep our right top skills. If you want to keep the top skill in terms of employees, you want to
Mm-hmm.
make sure that they are well motivated. If they are motivated, they will stay. If they
Mm.
stay in, they are loyal. If they are loyal, they will not leave. If they don't leave, staff turnover is always low. What is
Mm.
staff turnover? Staff turnover is calculated as the difference between the number of staff before and the number of staff now
Now.
divided by the number of staff before. If it is
Mm.
high, then it is not good for business. But
Mm.
anytime there is a change, you have to retrain, and that's cost, time.
Mm-hmm.
It affects productivity and everything. It even gives impression to customers and the community in terms of business reputation. So this flexi work is going to help motivate staff. If it's going to
Mm.
motivate staff, people are happy. They know that they have flexibility to meet
Mm-hmm.
family needs. That's work-life
Yeah.
balance. Because that's what the
Mm.
government is saying. Work-life balance shouldn't be work only for the employee and nothing for the only for the employer and nothing for the employee. Work-life balance. So it's a mutual bargain, mutual benefit. So the minister is saying that this policy is going to help employees so that there will be work-life balance. It will reduce depression. It will reduce mental health episodes or issues. It will help everybody and it will increase the economic output
Help.
or gain
Mm.
because it starts from the bottom and it affects the entire country. The employer will also benefit because motivated staff means high productivity.
That's right.
Motivated staff means no need to leave.
Mm,
Motivated staff means less time and money to train new workers.
that's it.
Motivated staff means it's not about even your money that they need, but the
Mhm,
fact that they even give you more than they are asking for or you are giving, and so
mhm.
on and so forth. So the employer benefits so much, and that is what the Minister of Employment is excited about. So that is the benefit to both the employer and the
Mm.
employee in terms of this new regulation.
Wow. Good. Sɛnea ɔmo aka no wobɛsɛ good news. Na more question kakra bi. Wɔn sɛ ebi mo adwuma no bi wɔ hɔ a saa flexibility ɛboa ɛne ɔyɛ ne dɛn a obi betumi abɛyɛ adu ha na obi abɛyɛ adu ha na obi abɛyɛ adu ha. Na some of the jobs no nso no wobɛsɛ ehia sɛ nipa baako betumi ayɛ towards longer hours anaa emi kora shorter hours. Na saa ɔmofoɔ no menim sɛ yɛka sɛ yɛkɔ mu a yɛbɛnyinyanya examples kakra na yɛkɔ mu a na sɛ company no na ɔno wayɛ ne nhyehyɛe saa sɛnea ɛbɛyɛ no nso na ɛbɛboa ne company no ama no agrow. Na saa nhyehyɛe a aba yi, sɛ company biara nso ɔba abɛyɛ employee obi a odi kan yɛ dɛn advertise the vacant of the job no, the vacancy no, na ɔde nneɛma nhyehyɛ a ɛwɔ saa yɛka ne sɛn position no ɔde ahyehyɛ ho. Nti no sɛ advertise sɛ bi a mepɛ teacher na ɔmbɛkyerɛ adeɛ Monday to Friday. Monday to Friday no wobɛhyɛ aseɛ anɔpa 8 na wapɔn 3 Monday to Friday. Saa na ɔno employer no wɔ advertise n'adwuma sɛ wo a wobɛhwɛ na woyɛ interested no na wayɛ dɛn wa apply. Nti no wohuɛ you actually saw what they are looking for before you did the application. Now waba bedu na mayɛ wo interview biara na wastart adwuma wobedu hɔ ɛnɛ na wosi daabi mentumi ɛnyɛ saa hours a wode bɛto kwan mu. Meanwhile no wohuɛ ansa na woyɛ application na me so mehu sɛ wobɛtumi ayɛ. It could even be say during the interview process no mema wosi supi wosi o metumi ayɛ saa hours a wode abɛgu yi ɛneɛ saa na me so magyina so kpɛn na mede ama wo adwuma no wobɛhyɛ aseɛ da koro mmienu pɛ wosi employer yi daabi o masesa m'adwen sesi ano sɛ na menyim ma wo nti no mentumi mentumi nyɛ saa hours a wode ama me nti ma me just Monday and Tuesday pɛ na menyɛ. Lawyer Asmah, sɛ lawyer ne ka sɛ daabi ade a mede to dwa ɛne na mede afa wo nti wontumi bɛsesa w'adwen a ɛdeɛn mmara na ɛwɔ hɔ I mean the consequences ɛwɔ hɔ ma employer no sɛ ɔmpene saa nhyehyɛe ne so because yɛsɛ yɛde new regulation aba for flexibility na nti employee no request ne flexibility but employer no say ɔde to hɔ sɛ sei na ɔpɛ no ɛna wabɛgye afa nti adɛn na ɔsɛ ɔsesa ma no mpakyɛw menim this is real practical situations a yɛfɛsi bebree den na employer no wobɛfɛsi.
Right. I think what I would do is to take you back. For what you are saying is that you saw the advert, you saw the job description, you saw the person's spec, you saw it, you were happy, you applied, and you started. Only to say that I want flexi. Meanwhile, we didn't advertise for flexi.
Yes.
But before, there was still flexi opportunity, just that it should have worked for 26 weeks. So the only thing that is changing is to remove that restriction of 26 waiting time to the very first day. So if the employer is making this argument, it will not wash because it was there before anyway. The only thing changing is that we are increasing the right of the employee and limit that of the employer so that the employee is not disadvantaged. So right from day one, instead of the 26 weeks, the employee can ask whether they yes, you advertise, they applied, and they knew what they were coming in, but they didn't make the law.
Yes, intino mpacho ubebem intino se waba na onim se oso ye adwuma before na oso ye adwuma 26 weeks and san obetumi atro na wasesa sa mra no enti se ye fa ne se probation period at least 26 no where you probation enti se me fa permanent and I say make say many anso wedwuma enti me fa permanent a eno nso ewo ho enti se sisia na ye free ho na waba oba adakro na o say there be me pese mesesa oho na mehu se ne amemfa no nti se wo cheche mu kakra.
Yeah, now yeah, can I say Emrano say this is the law.
Okay.
The law. Flexible Working Regulation 2023. And if you look at the Employment Rights Act, so this is going to be an amendment to the Employment Rights Act 1996. It's a flexible working amendment law. So 2024, there is amendment to what existed. What existed was that work for 26, and as you said, but so you see, the framers of the old law knew that you have to go through probation.
Yeah.
And give and take. 24 for let's say 6. Remember, probation is 3 months.
3 months.
So 26 weeks is it's more than the probation anyway.
Okay.
So it's not that the 26 was
6 months.
Come again?
If people say 6 months probation.
So if people say 6 months probation, even that, give and take, 4 6 is 24. That will be 24 weeks.
Yes.
Plus 2 weeks will be the other months now, or overlap, be a 31, it be a 30, and so on and so forth. So granted, say the framers of the old law had in mind that the employee has a duty to go through probation, pass probation before starting. This is one passing probation, which means requesting flexible work.
Okay.
That is the old policy.
Policy, okay.
Or the framers' understanding of what was going to happen. Now, the framers are saying that it is not fair to say that finish your probation before you can assert your right. Because anything can happen to you at any time. You can become disabled. You can become pregnant. You can even change your sexual orientation. All these things. And remember, these things then fall within the purview of the Equality Act 2010. The protected characteristics. And the protected characteristics cannot be engaged anyhow. And let's assume that anybody really probation. Now, we hear flexi work. Now, what's the one farmer now? Because the law gave employers power then, they were able to do whatever they wanted. But the law now is saying that from the 6th of April, that power is taken away. So they don't have to wait after probation, right from day one. That's what I'm saying. So whether they knew about what they were going for or not, the law says they have a right and they can assert their right. The right is that if your circumstance, having started work today, changes, they can ask for flexi work within 12 months. And within that 12 months, you can ask for this twice, provided there's another change. So that will answer your point. The point you make in favor of employers and the explanation I have given in favor of employees within the scope of the framers of the law, what the intention of the law is. The intention of the law is to ensure that what we are experiencing in the workplace and society generally with depression, with anxiety, with mental health is curtailed and minimized.
Yeah.
You see, so that is why. And again, people can have work-life balance.
Yeah.
So that everybody is happy. And as the minister said, that will increase productivity, increase profitability, increase turnover, increase sustainability, increase staff retention, reduce staff turnover, and grow the business. So you see, one small policy has a ripple effect on the employer's business. So it's even good news for the employer if they manage it well. But the point we are making is this. The law says the employer, he has a right from day one. And they have to request. Let me read this to you. It
Okay.
says that employers would not be permitted to reject a flexible working request without consulting the employee in question. So you cannot just reject arbitrarily, say no, without giving them reason by way of a meeting. Consultation means have a meeting with them to explain to them why it will not work this way, and if there is agreement, fine. Before, the employer could cite business reasons, as many reasons as possible. Of course, there are like 5 key reasons. We are not going to go into that. But before, the employer could cite business need reason to say no to you. But now, what the law is saying that whether you're going to say yes or no, you must have a consultation with that employee. So the employee must be happy for your no answer, or must be happy for whatever you are going to tell them. We start on the 2 months as opposed to 3 months, and everything must be in writing and can be kept on the employee's file. And the employee will also be given a copy to keep on his or her personal file. Now, we are looking at, and so what happens
Yes.
if the employer is so strict as to say that we are not going to comply with the law? The law says that, so let me take you to section 94 of the
Okay.
Employment Rights Act 1996. It says that employees have the right not to be unfairly dismissed. But that one, if they have worked for 2 years for disqualification, that right under section 94 is qualified elsewhere, and therefore must be 2 years working for the employer. So most employees who have just started and going for flexi work, an employer saying no and using any means to fire them cannot assert the right under section 94, but they haven't worked for 2 years.
2 years.
So
Okay.
what can they do? The law says that if it's so clear that any of the protected characteristics under the employment or within the Equality Act 2010 is being engaged, then employee can bring discrimination. Even if it is not about the protected characteristics, the employee can bring discrimination for
Yeah.
refusing to accept or to give them flexible work. The thing with discrimination is this. So this is the remedy for the employee who requests from day one and the employer says no without any tangible reason or without consultation for them to agree. You can sue or go to employment tribunal for discrimination, but you have to show that the employer's behavior, which is refusing to accept your flexible work request, has unfavorably been to your detriment.
Okay.
Unfavorable means, of course, you are going to lose out if the employer says no to you. But the question is, are you the only one that the employer is saying no to?
No to.
And
Okay.
that's the comparator. If the employer has said yes to somebody
And no
and
to
they are
you.
saying no to you, then there is discrimination.
Okay.
Because we can establish comparator. Why have you said yes to A and you are
And
saying no to me?
then.
So that is where we have to be careful. The employee can, yes, seek remedy under the law for discrimination, but the employer will tell the employee that you have to prove or make out your case. Your case must be proven to the effect that you can point to somebody who has been favorably treated and you unfavorably treated when both of you made the same request within the 12 months.
Enti and I'm say na brofo na ya adoso kakra enti no ye beka ni say tie o de o ka etre no, let's look at individual circumstances. Embia mo nyina ma akoye sa request no na because of maybe some way because of discrimination now the be mo no mo nyina ma akɔyɛ request for flexibility in terms of your hours no na yɛsɛ yɛde ama baako yɛamfa ama baako embia na mo ntro ye mo no obi a circumstance or the educo apply for we no embia na differ from yours enti yɛhwɛ no ne deɛ na yɛhwɛ sɛ no ne yɛ more memfa ne sɛ more urgent and I say ohia ne serious yen compare bi so a memfa ne sɛ awom ne ade nim so obia was yɛfa ne sɛ excuse a obetumi de use de acquire application but say employer no feel say we deɛ no emoso kakra anaasɛ ɛno no ɛyɛ pressing kyɛn wei na ɔde ma wei na ɔka sɛ bi a wo twɛn kakra anaasɛ menya mmoa wa ɛno no wobɛtumi atɛme ɛno as discrimination ana lawyer Asmah.
Asɛm a ɛsɛ bi sɛ yɛn ho sɛ kwan bɛn so na employer no faeɛ ɛma wote aseɛ.
Okay.
So mmara no sɛ wontumi a wo ne ne ntena ase na ma ne hu na ma ne nte aseɛ. Two things. Ma ne hu na ɔnte aseɛ.
Okay.
It is agreement na mba a wontumi nka sɛ no.
Right.
We are not looking majority.
Koso.
Enti sɛnea yɛkyerɛ mu no. Yes, ebetumi abɛsɛ obi deɛ ɛso si obi deɛ.
That's
but ɛnyɛ ne dodoɔ. Ɛna ɛnyɛ obi deɛ ɛyɛ papa si obi deɛ. Obiara deɛ yɛ papa. Say major flexi hour because of studies. Major flexi work because of family need, child care. Major flexi hour because of parental care. Yeah, family member be or area system support to. Major flexi hour because I can work part from home and part at the workplace because that is the order of the day now. So we are moving towards a point where there will be maximum flexibility. And that is why this new law has been introduced. And going forward, no, we will say a lot will happen about both employers and the employees. And the employer no can say yes. Nipa we need the a papa sin with the a assume sin with the intina me de man no a man farmer no. That is not the point. Point is say we are why you say one farmer no. And brother say when me enkasa na me chance here say me and I say won to me. You cannot just rely on business need alone. You have to make me aware for me to agree. I didn't know one year sa. So one year sa dia and there and to assume. Because say baako ne dia na ɛyɛ ntia. The moment about you who say baako bi ya dia ma no na baako bi dia yan farmer no na nipa no request no ɛyɛ within the permissible request and I say reason for request in there. Unfortunately, no, one year with my year as an employer.
Yeah, come my employers and yeah, come my employees. I just say yeah, try to have a balance here. Yes, now your employer na is same be back. Had to the baby hard drink a crack. Now, wow, him say, obi wo hɔ a due to ne experience nti no wode na hyɛ baabi a ɔno to me manage ne yie because of ne experience to me boost employment can I say productivity, let me put it that way. Na afei ɔbaeɛ a ɔsi o daabi sisi a mpɛ sɛ mete me mmra me mmerɛ no mete so because menya mewɔ circumstance kakra nti no mpɛ sɛ mete so na me fulfill wei kakra ne wei kakra na wohwɛ na afei na woba bɛtire ne obi foforɔ with sika foforɔ na ɔmbɛ replace bi a just ebi kora 2 hours po ebi wɔ hɔ a ɔyɛ ne saa 2 hours pɛ na ɔpɛ sɛ ɔte free ne hours na ɔwɔ so no na yɛ sɛ you have to employ somebody just for that short period na ɛno nso saa na akɔyɛ den ama employer no so enti no mmara no aba no ɛyɛ sɛnea yɛka ne sɛn prime minister kan yɛma ebi situation bi nso akɔyɛ tight kakra last month Asmah no sitting down or having that yɛka ne sɛ meeting for each person understanding sɛnea ɛbɛyɛ a memɛte aseɛ sɛ ayɛmbia wompɛ sɛ wode bɛma me anaa wopɛ sɛ wode ma me a mɛte aseɛ ansa na metu ho anamo na sɛ ba ne sɛ moatena ase na employer no nso akyerɛkyerɛ mu sɛ wɔho wobɛgye flexibility menim sɛ ehia wo nti na woba abɛgye na mehwɛ me nso me side na sɛ mede ma wo seesie a me nso me ho bɛkyere me kakra enti no sɛ wobɛto wo bo ase na wama me mmere kakra na either sɛ memfa ntraining obi anaa memfa recruit foforɔ na memfa nhyɛ hɔ in a particular like time frame na afei na mede wo deɛ no ama wo na sɛ kyenkyena a wowo si daabi adekode ntam bɛ request ade no nso yɛ urgent na mehia saa flexibility no sɛsi a yɛyi saa 2 months period na nka wobɛtumi ayɛ no yɛyi afiri hɔ sorry 3 months na ɔsɛ I don't want to confuse. Old one na ye free or nanka obey sa request no. Na ye at least employer know what 3 months to respond to you. Say see I ati 3 months na about 2 months. Inti ehwe bia na wentumi anko fulfill within sa 2 months no. So we employee na mpini a na employer no so insist say enye say me mpini o me say me pini na mom ma me mri say ni say mpacho oho no ye best strike balance ni say.
So, I mean, every case is specific and it is taken in context. So let me bring in this analogy.
Okay.
So our case study employee is called Nanny. Nanny started today. Yesterday, Nanny had a fractured leg, bone, disabled, cannot continue as planned.
Okay.
Nanny wants to work from home on some of the days and come outside on some of the days to the workplace. Is it Nanny's fault, say we pray? And that's why you're disabled.
David.
So it depends on the context.
Okay.
And there are so many of these contexts. Just a nanny, equal employer who are the employer make say, okay, Sunny at dia and you be say. Be a obey be fifi. No what that war a brain and I say kwan depend on the treatment no say na be kono. Wa be be nso aye den. I wo adwuma mu aka ho. That is mutual beneficial approach or mutually beneficial approach. And that's example I'm able to answer that question.
Eno ano no Asmah wacheche mu ye no ano no etiefo em say yakasa even though we still have few to give out na yakasa edu eche kakra na mere no so ko enti no mesre me producers say the telephone lines na betum so what question bia obetumi ebisa emfa ho say ne ye ka flexibility and ye ka flexible working hours ho asem obetumi ebisa question bia wo pese lawyer Asmah eyi ma wo moaye na obetumi ebisa na telephone numbers na yɛde yɛ adwuma na nsesa yɛ 0208123116 obetumi afrɛ ɛno sisia na yɛtumi eyiwa no fɛfɛɛfɛ saa nso na obetumi afrɛ yɛka ne sɛ 07399208468 ɛno nso wobɛtumi afrɛ ama ɛno nso yɛbɛyi w'ano fɛfɛɛfɛ na mmom ɛmbia na baabi a wɔwɔ no akwanya ɛmma wo sɛ wobɛkasa telephone so anaa wobɛfrɛ koraa ɛgyina so anaa mpo wofrɛ no na ayɛ engage saa so you can't get to through a wobɛtumi agya voice note ɛwɔ whatsapp saa whatsapp number no wokɔ a na wagya voice note tietietie just under 2 minutes sɛ wo problem nie na lawyer bɛyi ano de ama wo nti number no yɛ 075 na mesi etori bia na agbafa bitim kakra okay 075 966 20154 mesa esisi biom 075 966 20154 ubetumi afre na wonso webisa wo question me hu se obi di question bi aba na like I said sheda emfa ho say wo question no this topic based on this topic ebetumi aye bibia o pese lawyer eyiwa no their expertise no vast bibia ebi wo ho enti obetumi menya voice note ba ko lawyer mami ndi kan embisa na ansa na okay membisa ansa na maka ne me nka mebeken Maybe say no answer.
Hello, Manya. Good morning, Lawyer Asmah. Good morning. The Martinez, my power mobile my community. Sorry, I mean, own show now. But a quick question: a Ghanaian British descent, a Ghanaian descent but British, you're gonna. And now, Oba Warriors, it's also be British. Your Oba, on this one, I want to British. But Oba, no, I rely me for the paper, and I'm a rely no be a share no on paper. Number two, you were 2015, which is 9 years more. Now, DDB Akoso, the water balance be Akoso, I may say, separation by intimacy. Police near you for in my bill for the babe. Now, I say, they say, eat the boss. I mean, was I say, you mean the air gun of free? Customer marriage, yeah, accept that. Oh, UK laws. If it's me, I could die, oh, Ghana, but my way divorce no court Ghana. You say I married, customer no Ghana, you are come marriage certificate. But they say the bet now we divorce no Ghana because family phone in any baby and in Africa and the bet my no Ghana. And I say a wale or auntie also hang court and need me no Ghana. So I told me to my last my up one and I first.
How do you understand nipa no?
Me sure so tie yes. Sisi na
Is
ode
it a
ba.
call? Was
Yes,
it a
na ede
call?
na akwabo yire sa. Onti oye audio inti no. Otie lawyers ma ode obetumi ama
Question
asa
can
wo
maybe stand
question ya
say.
obisa obeti na wasa ye audio ni bi mu asa ba.
Question can person maybe stand na metim asie bebre ni say. So
Uh-huh.
wo ye wo ware wo krom ha dia.
Uh-huh.
Na still a wo krom ha. Why will
Uh-huh.
you go to another country to to go
Oh, sir.
to have it
Oh,
annulled
sir.
or to have the divorce? I
Yeah,
don't
me say
know
sikasem.
what the cost and time reason for this is. But
Lawyers ma.
aware wo krom
Betumi
ha.
aka say
Mo
sikasem.
nyinaa mo wɔ kurom ha nti munja aware wɔ kurom ha. Why?
Ena make say betumi aba ne say sikasem. Embia na divorce fee na ɛwɔ ha no. Ontumi ntua na ye krom de ya na yɛfo kakra. Enti na me na me yi ano ama no but pacho and pakọ the question ne ba no say wutie a wobetumi asa ye audio any question a lawyer ebisa say mo ware wa ha mo ti krom ha mabọ mo brain nyina wa ha ma wo wa ha enti no aden na wopɛ sɛ wo nkɔ divorce wo yere ɛwɔ Ghana say moyɛ customer marry na mmɛsa bɛware wɔ ha anaasɛ moyɛ customer marry nko a na nti mopɛ sɛ mo divorce wɔ Ghana but according to your audio no say mo worry wɔ ha nti question a lawyer ko onya answer na afi or the mmuaye e de ama but I think said the answer is within the question na obisa o no again the numbers to call 0208123116 or 073-9920-8468 ubetumi aka na ubetumi ebisa wonso wo de saa so na ubetumi eja voice note senia obi ja ne voice note e de maye yo obi ebisa question bi ya mo ntro senia mekan ya na mate asientem osin oh yeah, you can say skill migrant workers bi Mr. Mame mpagya de kakra. Skill migrant workers bi na waba one ne yire nyina na aba. One ne yire na ye adwuma be ye 3 months ni. Na ne yire ne se bibi nti o so Ghana very urgent na oba. Na mom opese nka okoche kakra. O so de na adwuma mu fo no ekasa na adwuma mu fo no sei obetumi akọ na emom omansi so pi sɛ ɔsɔ ɔba emre sɛ ɔsɔ ɔba emre sɛ ne kru na ɔwa ha no ebisa sɛ sa yɛn bia o na ne yere na mba biom a anaasɛ ne yere ne kɔcha sɛ ɔmo kɔ renew ɔmo nkrataa na ebe ha adwene ana em say sa question obi the similar one eba I think last week or last 2 weeks Emma ye kan ho asem but afe no no nso di ne dia aba lawyers ma osima si we dia na beto no
Ani ebe ha adwen say do renewal time no a.
ebe ha adwen na che say ne main applicant no absent no ebe affect application no okay when so say yeah man or your application skill migrant be or your application no Okay, or your application no somewhere in September. And I am from mana afeni de mano no yate your friend is saying 5 months a freeze nature say anyway no 5 years na de mano no ate so 5 months into obisa say in this case no so onim senka 5 years no obeye adwuma oba no obeye adwuma 5 years na nka wakoji indefinite ni straight away but sisi a yede ama no na yate 5 months na free so no or say oye adwuma na edu saa 5 na che say when to me and renew one sponsor ne ho a on to me enye indefinite na so also renew and na wakwa koye indefinite no but on the question here minim say what me ase ade a
Yeah, my two are here, but and I'm running can I say if you stay on the skilled worker route for 5 years, the sixth year you can apply. Yes, when you said there are disparities. If you have a card and not dating are different. Usually, I think almost share time no. I think the date of issuing a COS and so a place
play back.
impact or decision time no, and that's starting time of the visa no. Because there are instances that will be the same employer will be there a year 2.5, will be there a 2, will be there a 3, will be then. But the long and short is that you should have stayed on the skilled worker route for 5 years
5 years
before you can apply for indefinite leave to remain. And he said shortage about, I mean, these are conversations that can be had with the employer. So I count 6 months to get to have the 5 years. Obviously, even when you are doing the indefinite leave to remain, you have to show say there is propensity, say, and I said there's prospects, say, when the employer must give a lecture, do this, do that, and all that. In this employer, no, when you enjoy just because you are going for indefinite. Because you are not here because of indefinite. You are here to work. And indefinite is just a byproduct of your right as a skilled worker. In just I want to know 4.5. Now with this of course, you have to get it sorted.
Okay.
Then into the 5th year, you apply for indefinite leave to remain. And once you have no restriction, which is the indefinite leave to remain, you decide how to live your life in the UK.
Okay. Wow. And you know, yeah, I think say she should be answered because question will be sadness. They say in that case, no, date na was COS ne so na on fan Korea on peninsula na visa na they are born but I think say lawyer Asmah amount fine you can is explanation to your question. And you know, best no, and it's only employer no ebe kasa na if you are still in with the employer now, obviously also the amount. Unless say o pese wudwane ana o pese oni ni jai yo lawyers man ye go so ewa ha etem for o pese ubisa question na akwanya eda ho 0208123116 and I say 07 39920848 obi eja message ba ko ewa ha me hu Facebook ne YouTube ne so nti say question bi wo ho a ye betumi em say nipa ko na ode ni message ne ba no wasan ede answer no aba yentie hwe.
Hello, Manye, but me, yes, I may try from sim, but and yes, Matia the move kind and the Asma a kind. But yet, any say, we know, Madame Fobako, I trust we divorce or the 2 move from last year, February, up to now, on your results be your name himself the 2 May 6 months, and yet. Anna, Madame Fobako, a British, or no sooner a British, Matana almost 6 years in it. Omako divorce no Ghana, at their bar. Omatana 5 years, Hannah born brother. Omako divorce in their bar. Ama bibia, I successful man and her. And the main reason is so the 2 my eche, and I will see near the Padibia, whom I say, ye couldn't testify, and one year crano. Now, Cranzo or Mamono, some basic Hunabama Huno, and to ensure a big problem. To my main question is a pacho. Say a year marriage certificate, the borrower Hano. Bet me, I call Ghana. Akɔyɛ court divorce so the man for court divorce the ba harmony and na me person no patch what am met me akɔyɛ court divorce or Ghana da ba I come marriage certificate that's patch
Yo, now I think
Yes.
you among the family answer. I will not 7 no more. Also, the microphone, my quiet or Ghana, Abba, and my diary, and somebody may add a year or UK. Yes, sir. Then you don't even need a lawyer to add
to
to that.
answer you. So no, I'm an
And
answer.
to win him that. Why?
You say telephone lines no I block send your all can work prayer, but it's not coming through. So I'm very 100% sure say in prayer, but it's not coming through. In that case, no say we friend and go through a message say obe friend obe jam message or WhatsApp and I obet me a friend WhatsApp number no WhatsApp only obet me a friend WhatsApp number no na you know so edia tum edia ma enti no eno ne ade no enti me nua bema a woja message em say no na lawyer Asmah aka say wo wehu obi de na ayeyie dia ene say think say wo so koye a ebeyeye ana me nim say lawyer beka you ana obeka there bi no oh asatiko so obeka you ana also obeka say there bi no ene bema ubenya wohu lawyers ma wohu na me nim krofo bebre we have this situation or this mindset say sometimes we see things going on, but they wouldn't tell us the details of what they did. So, on my mind surface. But sometimes, yeah, you be salo, you be salo, and I can say, and I say, and on say ampa with the lawyer na aka enti no me gidi say me nua be me no no kompesa otie free wa no ansa na koma to ne yam sa na tie na ma obi a wo frɛ wo na ma ne end with 533 obetumi asa afrɛ biom wo frɛ ya na ka tie obetumi asa afrɛ biom yenua ba yenua ba lawyer ani enso wa ha memma ono nso de ene ade na yɛbɛkae no ɛnɛ koraa wobɛhwɛ a yɛka aborɔfo fa paa ansa na but then still that portion of her explanation or her way no ɛka ne sɛ submission no yɛtumi gyi ɛno nko ara na yɛde ato abɔnten de ama yɛ kurom yɛ neighboring countries ɔmo nka yɛn kasa no nti no mɛma ne akwanya na ɔno nso mbra na ɔmbɛdwiridwiri anim mfa mma yɛn sɛnea ɛbɛyɛ na omonya mfaso. Until Lawyer Anne, you are welcome. Good morning.
Thank you. Good morning, everyone. So I'll just be providing a summary of today's topic. So specifically, we looked at the new flexibility working regulations 2023, which will apply from the 6th of April 2024. So the right to request for flexible working comes from Section 80 of the Employment Rights Act 1996, which is known as a statutory application. So before I go any further, as Lawyer Charles said, all of this doesn't apply to self-employed people, since most self-employed people are not protected by employment rights. So this is specifically just for employees, which means that if you file your own taxes, or you do not receive, a salary, but rather you receive a commission, then it's more likely than not that you're self-employed, and so this wouldn't apply to you. So the first thing that we looked at is what a flexible working arrangement is. So it's basically where you put in an application for your work schedule to be changed. So normally, with full-time positions, you'd work from 9 a.m. to 5 p.m. But when you have a flexible working arrangement, or you put in an application for that, you're basically requesting for your schedule to be changed, for it to be more flexible. So for example, you're asking for part-time hours, or you're asking for your start time or end time to change, or your break time to change as well, or you're asking to work remotely, either working remotely some days of the week and going into the office the rest of the week, or completely, asking to work remotely. So we now we looked at the old law and how it worked with applying for flexible arrangements. So under the old law, you had to be an employee and you had to work 26 hours to be eligible to request for flexible working hours. And you could make that request in writing only once a year. So in writing, that would include like via email or using, letter. So you could make that request just once a year. And again, under the old law, your employer would have 3 months to consult with you and to basically decide on, whether they would accept that request or not. And they could also, when I say they, I mean the employer could rely on business reasons to refuse the request. However, under the new law, there have been slight changes. So specifically, we are referring to the Employment Relations Act 2023, which will, take effect from the 6th of April 2024. So you can make or you can apply for flexible working hours from the first day. So instead of having to, wait for 26 weeks, the first day that you come into work, you can make an application, for example, to work part-time hours or to work remotely. So that's from day one. And you can make that request twice a year. So instead of just being able to do it once a year, you can now do it twice a year. And it still has to be in writing, so either via email or letter. And the employer would now need to consider your request within 2 months, which is shorter. Initially, they had 3 months. So now they have to consider your request within 2 months. However, they can still kind of extend that time if need be. And they would have to, consult with the employee and also explain why a request is denied or why it is not denied. And the outcome has to be put in writing. And Lawyer Charles also explained why, or rather, he explained the incentive behind this. So he said that the Minister of Employment basically introduced this to help with the workforce. So in terms of the employees, it's to make sure that they remain motivated, because obviously if an employee requests for flexible working hours and the employer allows that request, the employee would feel valued, and so they will be motivated to keep working, and they will remain loyal. It is also good for their mental health. It will reduce stress and anxiety, and it will also help with their work-life balance. In terms of the employer, it will benefit them as well, or their business as well, because it will increase productivity. People will be more motivated, and so they will be more willing to put in the extra work. And then we also looked at what you can do if your request is not allowed. So it depends. If your request is not allowed and it's kind of linked to a protected characteristic, then you can take further steps. So when we're talking about protected characteristics, we're talking about age, disability, gender, race, religion. So if the request is not allowed based on one of those reasons, or you believe that it's based on one of those reasons, then you can claim basically discrimination under the Equality Act 2010, and that will be only if you can find a comparator, someone in the workforce who put in that request, and the employer was like, yeah, they accepted their request, but then with you they didn't. So you have to find someone in your workplace, a comparator, who doesn't share the protected characteristic, and their request was allowed. So that's just a quick summary for today. Thank you.
Thank you too, my dear sis. Lawyer Annie ho na yete nende no. Meda se. Me wo question ba ko bi wa ha. Me mbisa quickly na yenko. Lawyer Asmah, pacho me bo ama na iti.
Morning, Major. Good morning, lawyer. So maybe a question yama Obi. Nipa no the care package ni bi na buy na since buy obi bear for 3 to 4 months wa ha. Nipa no de ne buy no or sponsor no man adwuma bi anye. ɔpɛ adwuma foforɔ baabi na akonya bi susu a ɔmo sɛ ne way ne yɛ restricted nti mesrɛ kwa bi wɔ hɔ a wobɛtumi afa so etimi ayi ne ho afiri that restriction no mu na watumi anya adwuma foforɔ ayɛ nyɛ sa wɔbɛtena fie for almost 4 months ya ɔbrɛ nti yɛsrɛ mbɛtumi aboa yɛme nka mo ho de mase bebree yɛfrɛ me Kingsley bye
Lawyer Asmah, sa asɛm wei deɛ ɛyɛ nyinaa yɛdadwene nea ɛteɛ ne sɛ I'm thinking say during the application dodoɔ na I apply to come as a kid, they were not really informed well about the restrictions that comes with the visa. And then na ama create problems upon problems upon problems. Say tama nipa ko a ɔma wo saa sponsor no or explain kyerɛ wo sɛ visa na yɛde bɛma wo no restrictions ɛwɔ hɔ nie. megye de sɛ wonya saa explanation na ɛyɛ wo decision sɛ wobɛka sɛ yo wo deɛ mɛba abɛtwɛn anaasɛ daabi. Sɛ employer ne wo ne ba a under law no ɛyɛ employer no asɛdeɛ sɛ ɔyɛ dɛn ɔma wo adwuma na mmom yɛn nyinaa no sɛnea ɛteɛ nyɛ sei na yɛnyaa no. Employers ne bebree ɔmo ntumi andi ɔmo compliance so ɔmo nhyehyɛ a ɛda anaa mmara a ɛka yɛfrɛ ne sɛn wei no ho no ɔmo ntumi anka. Nti Lawyer Asmah mpatwɔ deɛ na ɔbɛka afa ho mesrɛ wo.
I think yɛnwei pɛ sɛ yɛka biribi kyerɛ no na ɔhu anaasɛ ɔnya nkwanhyɛ. It is what it is, unfortunately. You've been shortchanged. Oba in adwuma ni hɔ. It's possible say obedu ya na adwuma no akɔ the employer no cannot really do much about it. Unfortunately, you don't have any right because on can say oyiwedi kura untumi enko court under Employment Rights Act because unia 2 years ewo adwuma no emu. Ti na obaya no say obeye kom na wakɔ employer no wonde de bia no wa remind no say the bang na yahwɛ sɛ ɛnkyɛ no obama wɔ adwuma no bi ma wayɛ. But unfortunately you don't have any right. The only right you have is under contract because they promised you. There's something called promissory estoppel. They should have kept to that promise, but I'm sure they also have a good reason why the promise is not kept. You relied on that promise, so there is reliance, there is expectation, and all those ones in Nano say, then obetumi aye. Fine, but like I said, there's breach of contract. Then you can make a claim under contract, but untumi make a claim under employment law. Tina obe kan say, ono so baka say odwa ba abrochire anyway. Nti say wotim ase. Nti tina ase na woni ne nkasa why? Yenhwe say nyama be ya. But unfortunately from the legal point of view no, there isn't much I can say.
Lawyer Asmah da say isa nsɛm ne deɛ aha adwen na nea ɛyɛ ne sɛ wherever you go and then even seek for the 20 hours that comes with this, you can work in other employment for 20 hours. The same sector now. Almost yes, under the law now, you should be working with your sponsor before they can even offer you that 20 hours. Obi no obe offer you 20 hours na bra, you are not working with the employer. Enti no ama no aya insintibia ebi ema saa ade. Afen so lawyer question back bi so a me person me bisa was ade. Say wakonya company bi or so person offer full employment enti no o company no entro letter emma permission a obetumi de eyi restriction like release from ono ne sponsor ne so na ono afa full employment na. Is it between the employers who should communicate and I say who new employee now who come before from who also catch a sponsor and say o person o be person of offer full time so ono nye sa letter no no fa ma mpacho muna muni employment mo kakra e no senate.
Wait, this has nothing. We no any employment law. We appendix skilled worker provision no arrangement ɛwɔ hɔ no makwan say you can switch between employers nti wo ba na wo ne company A na ɛyɛ adwuma na company B say of or ma wo adwuma wo nya adwuma na o ma wo COS but now switch it to now become company B no ne sponsored staff nti minim say nkrofo kan say o makwaje letter o say okay me ma wo letter na wo de akɔpɛ adwuma me ma wo letter na wo de akɔpɛ adwuma but letter na wo de ma no is not stronger than aban mra na wa hyehyɛ no ɛne yɛ informal arrangement bi but so nipa no betumi apɛ adwuma na wenya n'adwuma na wenya new COS di a betumi switch from old employer no akɔ new employer no hɔ ɛma na yɛ yie.
Okay, your lawyers ma meda asiye tie for ye de dwumedie no abawie ye abo du ba 11 na ye be sorry ye na so no me sa bom nkai se nyame adoma ochina the community and the law no ebeba so den ye wo very sound topic bi e ba be echeche mu wa uti a obo se kai we de bebo for the next 2-3 years and to no make a date with us. Community and the law is coming on 4 o'clock to 6 o'clock. Ochna platforms ni nyina so ubenya BW radio, BW live, BW TV, ubenya chese BW solicitors platforms ni nyina various ubenya so intibo and date na wabi share wo ho. Sanso na se umrebi bibi hawadwen na uhia lawyer say lawyer kan wa asem mawa ewom say lawyers no sikanti na mo ye adwuma nanso mo wa abada mo hu mobo obetumi no atena sa hyehyɛ sɛ wasɛm wei ɔnte wasɛm na ɔmbɔ obo sɛ wate wasɛm no na ɔte wasɛm na ɔhwɛ no bɛbɔ obo nso na wontumi a ɔwɔ akwanya a obetumi ne watena se ne ahyehyɛ ne aka sɛ o se ni nti yɛnkɔ ni sei ɔmo yɛ nipa da se ne ma yɛ nsuro lawyers na yɛ nkɔyɛ ade na nkɔsɛe ɛkɔsɛe wie a ansa na na afi yɛ demeka akɔpɛ lawyer kyerɛ akwan saa time na yɛabɔ ka mmienu a ɛho hia saa nso na menkɔfa kwak lawyer obi wetie BWF Solicitors for saa for the past 30 years almost starting education Emma says you no so friend ne ho lawyer enso book kron kan bio ukohu saa nkrofo no nso a obetumi aye bi de na emmom mesrew ontumi ndi nkonim ma obekwa akopem na waje usika edikwa enti kona ko ho real lawyers me recommend the BWF Solicitors they amount omo abotre omenya wo ho time no metie wo no mahwem se wasem no ewu se den omehu kwan a ombefa so omenyane no na enkwa asabe monti no just call them on fourth floor Anna House. Just visit them on fourth floor Anna House or 214 to 218 Tottenham High Road. So it was Seven Sisters Tube Station. So or more. In case you are driving, you needed the postcode to drive towards their premises. Now, N154NP. O drive dia mef kase Tesco kakraka bi ewo mo nchen ho na otumi ko park wo 90 minutes free parking na with Jamaica akohu omo baby wo Scotland wo Wales wo Bristol wo baby emu twen nanso what BWF Solicitors nka wo pese omudi wedwuma mawa brother sister ehun hia se obetu car ana obefa train all the way from Scotland, Ireland, they are back BWF Solicitors are so Debbie. And just amre ne kra. And no I say free telephone or me to me buku telephone appointment or me to me buku Zoom appointment or me to me your Skype appointment or me to me no kwanye bia or betina ufie no me no ahisha ho pepepe. Ehia say all the document bi kra embro mo a omo akwanya omo to me di document abra wontu kwan enti me nua be ma me nua ba entna na asem no ensei ansana watu anamo oti krom wa 20 years uni nkrata uni kwan so a obefa obenye bi BWF Solicitor say bra na beku omo no mo nim enye bibia na eka o telephone so ena enye bibia nso na eka o radio TV ne so a wo hwe mi ebi wo ho a ye friend efikyire nsam ne de yekono boko na watu krom kasa na se na ayama ti kona ko hu omo media ne manyeti megide se weni aso Asmah eden na odi jaye
Yo etiefo ne ahwefo na nso yɛda mo asesɛ mo nya mre na yɛn nyinaa yɛtumi asua adeɛ na aboa yɛn ho na yɛate nea ɛba no ase. Na nea yɛka ne sɛ ɛkwan ebie ma adwumayɛfoɔ anaasɛ work employees. Na wei no yɛ nkurɔfoɔ a wɔyɛ adwuma ma obi. Ɛnyɛ nkurɔfoɔ a wɔyɛ adwuma ma wɔn ankasa wɔn ho. Nti w'adwuma no a woyɛ no, akɔyɛ te sɛ waa na woyɛ adwuma ma wo ho a because of arrangement na wo ne nipa no wɔ no a ɛndeɛ wei no wonka ho. Nti hwɛ sɛ woka ho anaasɛ wonka ho a. Na sɛ wohu na woka ho deɛ a ɛnneɛ mmara no se sɛ wohyɛ adwuma ase from 6th of April a wobɛtumi saa da no a wagye flexible working arrangement. Ɛno ne sɛ wode application bɛtum wobɛtwerɛ akɔma employer no. Wotwerɛ ma no a wobɛka nea nti a wohia sɛ wobɛyɛ part time anaasɛ wobɛyɛ remote plus on and off. You come to work some days, you work from home some days, and so on and so forth. And as I will call steady leave, be whatever it is, in terms of arrangement, who feel say, who when the employer and better nothing, when the bad good crack as well, man. Employer and better now I'm who employer 2 months mu. On to me, or no better nothing, actually say my member kakra, na mean you are no. Say, Quabe say, on to me, mmara no say ɛsɛ sɛ mo nyinaa mote mo ho ase. Ayɛ a na employer no bɛka sɛ because of cost ebi a yɛnyɛ obi bɛn replace o, ebi a yɛnyɛ say, ebi a yɛnyɛ say, ɛno na yɛfrɛ no business needs. But sɛ ne business needs no nti ɔntumi mfa ama wo a ɛsɛ sɛ employer no ɛtena ase na ɔmo no ɛkasa. But the same time so no ɛsɛ sɛ employer no hwɛ sɛ business needs no should not ɛne sɛ ɔbɛ override anaasɛ ɛbɛ shadow saa employee no ɔno nso ne need. Nti ɛyɛ bargain a mo mmienu nyinaa ɛsɛ sɛ ɔmo strike a ɛbɛboa mo mmienu nyinara. Na kane no sɛnea yɛaka no na ɛsɛ sɛ woyɛ no 26 after your employment. Sisi ano from April the 6th no saa da no a wobɛtumi de atum. Na mmom ɛsɛ sɛ wokyerɛ mu nea nti a wohia saa adekodeɛ no. Ɛna aban ɛkyerɛ mu nso sɛ ɛsɛ sɛ woyɛ no formal. Nti woyɛ no formal na employer no so responde no formal. Sɛ kɔba sɛ ɔmo si deebi a anaasɛ saa nti ɔmo gyina so aka kyerɛw sɛ wampase probation a ɛno yɛ different matter. Sɛ mampase probation a you have to show why I did not pass probation. For probation no ɛsɛ sɛ woyɛ wo probation no employer no support wo kosi time a wobɛwie until sɛ employer no bɛhu sɛ wo deɛ nea skill no a wowɔ no ane sɛ nea woyɛ no nso ɛni koraa nti ɔntumi ɛne wo nyɛ adwuma no nti ɔmpaase wo probation no ɛsɛ sɛ wonya evidence ɛkyerɛ sɛ ampa ɛnokorɛ sɛ ɔyɛ nea ɛsɛ sɛ ɔyɛ biara na wampaase wo probation. But ɔntumi ngyina sɛ wakɔbisa flexible work nti ɔde fail wo probation abere a ɔmprove nea ɔyɛ boa wo during probation nti a ofili sɛ wonyɛ competent to continue. Ɛna sɛ kɔba so sɛ wamfa ama wo na wane wantena ase ankasa na mo nyinaa moante mo ho ase a mmara no sɛ wobɛtumi ɛne no afa mmara kwan so under discrimination sɛ w'ani wendi ne yie. Na ɛno no ɛkɔba sɛ ɛsɛ sɛ wokyerɛ mu sɛ ɔne obi di ne yie na wo deɛ ɔne wo ndi no yie. In terms of unfair dismissal no wontumi under section 94 no wontumi agye sɛ wo ne employer no ayɛ adwuma 2 years ansa waka sɛ ne reason a ɔde dismissal no is not reasonable in all the circumstances until it has been unfair. But sɛ ɛkɔba sɛ wokɔbisa flexible work na adwuma no wura se deebi a acres foɔ ɛwɔ hɔ wobɛtumi afrɛ acres anyway di nkɔmmɔ wode wansam akɔto ɔmo anim ɔmo bɛkyerɛ wo na ɛsɛ sɛ woyɛ ɔmo ne employer no nso bɛkasa na obi biara ate ne ho ase na yɛde yie ato yie. Nti aha ɛna yɛde nkɔmmɔ no ɛbɛsi ɛnnɛ. Nyame nhyira yɛn nyinaa. Yɛbɛhyia ɛkyena ɛwɔ afidie no ɛso. Nyame yɛ adom a Uncle Ben ne yɛn ɛbɛhyia. Nti mo nyinaa momma yɛnyɛ krado 4 p.m. yɛnhyia Uncle Ben ɔde nsɛm dɛɛdɛ foforɔ ɛbɛsan abrɛ yɛn. Nyame nka yɛn ho.
Nyamenka ye ho lawyer Asmah ye beda wase yi papa itifo na ahwefo em sa ha na emre be ma ye nkwan na ye de edwumedi no abewie ye megide se weni aso weni age ho na wafa bibi kan ewo nti no share ma ye na enko echi na obi nso nya ho mfa so nyamenka ye ho na have a lovely weekend na next week e be sen hie bia mema mo nyina bye bye.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate, or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there's a will, the named executor is responsible for ensuring that the estate of the deceased is secured, assessing its value and paying any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.